Hey y'all, welcome to Crank That Whip. And today I have part 1 for the DUI ABCs. Yes, I had lots of fun making this for you guys, so I hope you enjoy. A is for administrative suspension. Drivers that are suspected for DUI are investigated and arrested for a DUI once they have the probable cause. The administrative suspension comes when the person submits to the breath, urine, or blood test and they have the 0.08 or above. That's the driving with unlawful breath or blood alcohol administrative suspension. And then when they refuse to submit to the breath, urine, or blood test, that's the administrative suspension for the refusal. The administrative suspension stays in administrative suspension until court. That's when it becomes a DUI. Bureau of Administrative Reviews adds either the driving with unlawful breath or blood alcohol level or the refusal suspensions. They can also invalidate or remove those suspensions, and they can amend those suspensions. The administrative suspensions stay on the driving record for 75 years. Might as well say forever, right? And when insurance companies run your driving record, or employers that you're trying to get a job with, it's going to look like you have a DUI, that administrative suspension. So your insurance rate may be higher and you may not get the job that you want because of your driving record. B, I have 2 B's. The first B is the breath test. After being lawfully arrested for DUI, the law enforcement officer should ask the driver to submit to a breath, urine, or blood test, whichever is, best for the type of suspicion that your officer has, whether it be for alcohol or drugs. Alcohol, they should ask for a breath test first. If it's for drugs, they should ask for a urine test. But the breath test is the first test that should be asked of the driver after being lawfully arrested for a DUI. The breath test machines are either in the patrol car or at the jail station. Either way, it's usually recorded and used as evidence against you later. Now, let me tell you folks, the breath test or any test the officer asks for, determining if they are having that illegal alcohol limit in their body or drugs, it should be after the driver is arrested, folks. Yes, that's the way it goes. You have to get pulled over, get investigated, get arrested, then get asked to take whatever test. Sometimes the officer gets beside themselves, they move too quick, or maybe they're just inexperienced and they may go right to, let me get a breath test, while they didn't even arrest the driver. If the request for a breath test was made prior to the DUI arrest, that suspension would be invalidated. The next B is for bloodshot eyes. Alcohol causes blood vessels in the eyes to be enlarged, filled with blood, making them bloodshot red eyes. This is usually the second indicator of somebody being under the influence of either alcohol or marijuana. Now, if the driver has the odor of alcoholic beverages, slurred speech, admitting to the consumption of alcoholic beverages, more than likely, their red eyes is due to alcoholic beverages. C is for court. The Florida DUI citation brings a court date. When a driver is issued a DUI citation, they have to go to court. They can hire an attorney to go for them, but there is a court date. It's a criminal offense and it requires a court appearance. The court's information is on the Florida DUI citation. So they have the information where the driver needs to contact to find out more information about their court case. And the DUI case is not for the DUI, the driving with unlawful breath of blood alcohol, or the refusal, folks. A lot of times when I used to work at the DMV or specifically bar, drivers would think they were going to court for that administrative suspension. No. The administrative suspension, you have to go to the DMV to challenge with the Bureau of Administrative Reviews with an informal or formal review. D is for DUI, driving with unlawful breath of blood alcohol level. The first offense is a 6-month suspension, and the second or subsequent is a 1-year suspension put on by the Administrative Reviews, the Bureau of Administrative Reviews. And this is one of the 2 administrative suspensions. Remember, because there's the DUI and then there's the refusal, which this administrative suspension stays on the record for 75 years. And it can be removed if you win a formal review, or you go to trial with the jury and you're found not guilty. Dismiss won't work, and having the case drop down to a reckless driving won't work. It has to be a trial with the jury and you're found not guilty to have that DUI removed from your record. E is for eligible. Everyone that gets a DUI is not eligible for a hardship license, so they can continue to drive after they're administratively suspended or DUI revoked. You have to contact the Bureau of Administrative Reviews to find out your eligibility. Repeat DUI offenders are not usually eligible to apply for a hardship license. If the driver is eligible, there's a hard time that may be required in some cases. And then there is a traffic school, the DUI, level 1 and level 2, or for the underage, the under 21 suspensions, the traffic law, substance abuse, or the basic driver improvement course may be required for refusal cases. You have the traffic school, then you have to complete the application, pay your filing fee for the $12 for the Bureau of Administrative Reviews, and you have your hearing. Now, everybody who have a hearing is not guaranteed a hardship approval. You either get approved or get denied. It's based on your driving record, and it's based on your testimony. Also, whether you have continued to drive after you were sanctioned. If you have continued to drive and you got pulled over and got caught, got a driving while license and suspended ticket, you are more than likely not going to get approved for a hardship license. F is for formal review. To fight or challenge the administrative suspension, drivers can request this formal review. Formal reviews will be with the arresting officer, the breath technician, the firefighter, a paramedic, a witness. They can be very complex hearings. It all depends on the attorney. They have to subpoena the witnesses or the law enforcement officers to come to the hearing. The hearing can also be with just the driver and with just the driver and the attorney. It doesn't always have to involve other participants. The formal review filing fee is $25, and to apply, you contact the Bureau of Administrative Reviews after you receive your DUI citation, and you fill out the application. You have to have a copy of your DUI citation, and the hearing is set within 30 days from that request date. G is for guilty. Drivers have to go to court for DUI, and if convicted, if found guilty, it will mean jail time in some cases, fines, interlock device, FR 44, and drivers have a driver's license sanction added to the record, folks. It's the DUI revocation. When drivers are convicted for DUI, the hardship license that they may have for their administrative suspension, which is the DUI or the refusal, it's going to be null and void at that time. So they have to reapply for another hardship license. Only the first time DUI offenders are able to apply immediately. All other DUI offenders, second, third, fourth, they're not eligible to apply immediately. The second DUI within 5 years from the first conviction is going to be a 5-year DUI revocation, and then they have to wait 1 year to apply for a hardship license. And then the second DUI longer than 5 years from the first conviction, it's going to be a 1-year revocation. Drivers are not eligible to apply for a hardship license. Then you have the third DUI revocation, which is within 10 years from the second conviction. You're looking at a 10-year revocation with a 2-year waiting time before you can apply for the hardship license. And then you have the third DUI longer than 10 years from that second conviction. You're looking at a 1-year revocation. And in that case, there is no hardship license. And then when you have the fourth DUI permanent, it's a 5-year waiting period before the drivers can apply for the hardship license. Speaking of hardship license, that's what H is, hardship license. Drivers, when eligible, can apply for a hardship license. There's an application, traffic school requirement, and a filing fee. The hardship license looks and feels just like a license, folks, because I used to get asked this question a lot. Like, what is it going to be? Is it going to be a piece of paper? Is it a license? What is the hardship license? It's an actual license. You take a picture. It's a license they printed out. It's real small writing on there that's going to say either employment purposes or business purposes only. And it has the expiration date for that restriction, because the restriction does expire at some point unless you're permanent. I is for informal hearing. This is the second type of hearing that you can request from the Bureau of Administrative Reviews when you get an administrative suspension, either for driving with unlawful breath to blood alcohol level or for refusal to submit to breath, urine, or blood test. The DUI packet is reviewed for errors by the hearing officer, and the decision is made to either invalidate, which is remove it, amend it, which is maybe change it from do ball to refusal, or either just sustain that joker. Leave it alone. Leave it right there on the record. And please, let me just tell y'all something about this hearing. Please don't ever request an informal hearing unless you done spoke to an attorney who done reviewed your packet and they see some errors that was made. Because otherwise, it's pointless, folks. It's pointless. Because the hearing officer is taking the packet, looking for errors. That's what they're doing. There's no attorney sitting there telling them, hey, this is what happened. This is why I need to be removed. The hearing officer has to look in the packet themselves and determine if there's enough to sustain the case. What they're looking for is at least 2 indicators of DUI, along with that, odor or alcoholic beverages, or just 3 indicators of DUI before the DUI investigation began. After the DUI investigation began, more evidence was gathered. They looked for that, and then the driver was arrested. Was the driver arrested first before the breath test was asked? Was the 20-minute observation period followed? If the driver refused, were they told the consequences? That's it, folks. That's all. So like I said, unless the attorney has looked at that paperwork and say, hey, this is not right, you need to request an informal hearing. It's $25 and this will be gone in a few weeks. Unless that's the case, baby, do not request an informal hearing. This one is also $25. You need your DUI ticket, citation, and you need the application. But this right here, folks, just remember, informal hearing, unless you done spoke to an attorney that told you to request an informal hearing, please don't do it. Because what you also missing out on is a 42-day temporary permit. With the formal review, which I didn't mention, a 42-day temporary permit is issued. With this informal review, there's no permit issued. So the drivers that request a formal review, they get to drive while their case is being held. While this informal hearing does not have a permit. Those drivers are without a driving privilege, and they are going to be without that driving privilege while their hearing is being held, unlike the drivers that request a formal review. Part 2 is coming out on this Friday. Stay tuned, folks.
Crank that wheel.
Show your girl some love.
Crank that wheel.
Subscribe and follow
Crank
me.
that wheel.
Check out my episodes.
Crank that
Crank that
wheel.
whip, baby.